In your case, just one or two preliminary matters. If there's any technical issues that develop during the proceedings, please let us know immediately so they can be addressed. We are proceeding as if we are in court on these matters, but however, you will not need to stand to appear to be at a podium, anything of that nature. Are there any preliminary matters, Mr. Clerk?
No, Your Honor.
Then would you please call this case?
Richard J. Hartigan et al. Versus Arnold Brush et al.
For the appellant, are you prepared for your argument?
Yes, Your Honor.
You may proceed.
Good morning, Your Honors. My name is Jerry Becker from the Knox County Bar. I represent Arnold Brush. Your Honors, as you know, this is Hartigan versus Brush 2. This court entered an opinion in this case on February 4, 2020. And in that opinion, on page 6, the court made several notations relative to the obligations that it felt that the trial court had to meet in its assessment of this case. And the Court of Appeals said that the trial court made no findings with respect to the circumstances surrounding the 2016 sale of the property, with respect to why or when the sales price was reduced, with respect to the appraised value of the property by 3 appraisers in June, July, and August 2015, and whether or not the substantially reduced sales price accurately reflected the real estate value of the property at the time of the breach in August of 2015. It's the position of the appellants that the trial court did not respond to the questions that this court wanted it to respond in a subsequent hearing before the chancellor. The subsequent hearing was held on June 16, 2020, before Chancellor Frank Williams. I think it's important to note, Your Honors, that at the outset, Chancellor Williams made it perfectly clear that he was not going to give much credence to the appraisals in this case. The court said in part of its opening paragraph that the court is not bound to accept the opinion of any expert, but should consider expert opinions in light of all the other evidence in the case. Now, the expert opinion in this case has to do with the appraisals on the property. This property was subject to being sold in, I believe, in September of or June of 2015. The agreed upon sales price was $712,000. In July and in August of 2015, 2 appraisals had been obtained on this property. One appraisal was obtained on July 20, 2015 for $730,000. The second appraisal was obtained on August 11th, 2015 for $712,000. Both of these appraisals clearly validated the asking price and the sales price of this property for $712,000. And it's important to note that both of those appraisals were entered by the Hartigans, the appellees in this case. These were not appraisals obtained by Mr. Brush. Subsequently, there was a breach in this case, and this court is asked to determine what is the extent of.
Counsel, these are the 2 appraisals that the trial court discounted?
Yes.
Okay.
And there was no controversy as to the accuracy of those appraisals or their validity. In fact, the lending company institution won those appraisals and got the appraisal of $712,000 subsequent to the $730,000 in order to validate the $730,000 appraisal to be used as the basis for the mortgage financing. The trial court instead focused its attention on what it deemed to be the circumstances surrounding the sale of the property, which occurred in 2016 for $550,000. That sale, I think, occurred in September of 2016. in terms of the applicable law in this case, the court very well knows that, as stated time and again, the general rule and proper measure of damages available to a vendor as against a breaching vendee in a real estate transaction is that the vendor is entitled to the difference between the contract price and the fair market value of the property at the time of the breach. And it seems to me that the trial court was centered more upon determining the fair market value of the property in 2016 and as to whether the $550,000 was a fair market value price, instead of, as the law requires, that it be determined as of the time of the breach. At the time of the breach, the two most affected appraisals within 1 month to 1.5 months of the breach, each were $712,000 and $730,000. The court very well knows that it can find that a trial court abused its discretion when it applied an incorrect legal standard. And it's our position that the trial court applied an incorrect legal standard because it looked at what it perceived to be the fair market value in 2016 instead of what the fair market value was at the time of the breach in 2015. The trial court went on to discuss the circumstances surrounding the sale in 2016. And the only thing that I can see that what the trial court attributed to be a fault of the Brushes, besides the breach, was that furniture had to be taken out of the house by the Hartigans because they were moving. And as a result, that the house was not as properly, as well staged for the subsequent sale as it was of the time of the initial sale to the Brushes in 2015. And that was the only thing attributed to the Brushes. The court did make note of the general economic conditions and referred to the coal ash spill as something that may have affected the sale, but it's worthy to note that in its first opinion, the trial court found that the ash spill had no effect upon the sale. The trial court time and again, throughout its opinions, recognized this was an incredible house, both in terms of its value, its view of the surrounding area, and called it a spectacular house, well worth a $1 million initial listing price. So the court found this to be a very difficult house, I suspect, to sell because of the high value, but nonetheless, the court fully appreciated its value. What the court said was that this was a one-offer sale in 2016, that it was a fair market sale because of a willing buyer and willing seller, neither under the compunction to either buy or sell. It's our position that the trial court erred because it did not take into account at the time of the breach, which is as much a part of the rule as how the court is to look at the listing price or the contract price, and then the price at the time of the breach. The court was looking at the wrong time. It should have been 2015. The court refused to do that, and as such, we believe, along with other items that we've cited in our brief, that the trial court was wrong, and that the trial court should be instructed to issue an opinion that the damages, in fact, were zero, because the sales price was $712,000. The appraisals at the time of the breach were either $712,000 or $730,000, and as a result of that, there was no damage to the vendor, to the seller. We ask the court to enter that as the finding of the court as to damages, and therefore doing so, prejudgment interest would not be awarded. Thank you very much for your time.
You have your time for your rebuttal. And for the appellee.
Thank you, Your Honor. My name is Sharon Clark. I'm the attorney for the appellee, Richard and Layla Hartigan. The judgments that were awarded to Coldwell Banker and Lakeway Realty were not appealed. The appellant's breach of the contract is not appealed. There are 4 matters that are before the court. Mr. Becker only addressed really one of them, or I suppose 2. There are 4 matters, and I want to make sure we address all of them. One of the appellant's arguments is that the trial court incorrectly entered its order. They believe that the trial court erred when it did not find credibility in the appraisals. They have appealed the court's assessment of the fair market value on the date of the breach being the subsequent sale. And finally, that the trial court abused its discretion when it awarded pre-judgment interest and post-judgment interest. In discussing the entry of the order, the appellant cites 2 cases in its brief in support of the fact that the trial court incorrectly entered its order, and that was a Supreme Court case, Smith versus UHS Lakeside in 2014, and Cunningham versus Eastman Credit Union, an appeals court case in 2020. Both of those cases are factually distinct from ours. In the Smith case, the trial court basically said, I rule in favor of the defendant, and asked the attorneys to prepare the findings and conclusions to support that ruling, giving the attorneys no guidance. In the Cunningham case, the trial court took the case under advisement, did not make a ruling, and asked both attorneys to prepare orders asking the court, or to tell the court what the ruling should be, and the trial court entered it. In this case, the trial court gave an elaborate ruling from the bench at the end of the trial and at the hearing on remand. The trial court elaborated as to why it found the subsequent sale being the best measure of the fair market value on the date of the breach. The court did indicate that it did not find credibility with the appraisals, and a lot of that being, and he announced it in his ruling, was because of the testimony of the appellant himself and the arguments made by appellant's counsel, not Mr. Becker, but the appellant's counsel at the time, indicating that the comps that were used in the appraisals were nowhere near the property that was being appraised, and they went to a lot of detail to explain why that was an issue. The court announced that it took time to sell the property, but the time it took to sell was about the same time as it took the first time that it was on the market. The first time it was on the market about a year with a single offer. The second time it was on the market was 10 months with a single offer. The trial court found that the second sale was an arm's length transaction, that the marketing method was virtually identical to the marketing method used in the first sale. The contract found that the contracts used in the first and the second sale were virtually identical. And the trial court even addressed the issue of the lack of furnishings as for purposes of staging of the property, when it said that when the property became vacated in anticipation of a tentative closing date, and that was in early August. The defendant knew that and didn't breach the contract until September 7th when he failed to close. So to the degree it was unfinished, the defendant knew that when he breached the contract. Counsel for the appellant submitted at the hearing on remand findings and conclusions to the court for entry, and the court would not do that. The court did allow him, though, to enter that as an exhibit. In deference to that, we took that order, modified it to track with the court's ruling, because the findings and conclusions prepared by the appellants did not track with that ruling, and sent it back to counsel for the appellant for review. Counsel for the appellant refused to enter that order, saying the only order they could enter was the order that was submitted at the hearing. So in accordance with local rule, I submitted both the order that was prepared by counsel for the appellant and the order that I had prepared. And ultimately, the court did enter the order that I prepared on behalf of the appellees. It's important to note that appellant's counsel did not object to that order, nor did they file a motion under Rule 52 for any additional findings of fact or alteration of the order. As to the discrediting of the appraisals, obviously the findings of fact, and I think this court knows that the findings of fact at the trial court are reviewed with a presumption of correctness unless the evidence preponderates otherwise. There were 2 appraisals that were entered as exhibits, and I would suggest Mr. Becker has some of the facts inaccurate. The first appraisal was $640,000. The second appraisal was $730,000. The third was not an actual appraisal, it was a review of the appraisal, and they came back and the appraisal met the contract price, presumably because it wasn't an actual appraisal. It met the contract price, presumably because that's what a willing offer buyer made to a willing seller, and it was consummated in a contract. The appellant testified in his direct testimony. He found weaknesses with both of the appraisals that were entered as evidence. They were entered as evidence when the lender testified for purposes of showing that the financing contingency was going to be released. The appellant did not testify at the hearing that the fair market value was reflected in any of the appraisals that were submitted before the court. And as a matter of fact, his counsel cross-examined the lender, pointing out all of these issues with the appraisals. However, before this court, they then argue that the appraised value should be the value on the date of the breach. At the hearing on remand, the trial court asked us as counsel to read into the record or to have any additional testimony we wanted considered for additional findings of fact when it came back on remand from our first appeal. The appellant did not read in any of the record at the hearing. I did read in the record, and a lot of that was the defendant's testimony as to his discrediting of the appraisals. The appellant asserts in their brief that somehow that reading was out of context and reframed the defendant's opinion so that now he was in favor of the appraisals. We suggest that that was not a reframing or read out of context. If it was, they certainly had the opportunity to read in any portions of the record at the hearing on remand that they chose to do that. We believe that the appellant waived the argument at trial and at the hearing on remand, but assuming that it was not waived, the defendant in his direct testimony said that none of the comps were in Roane County that were of the appraisals when he was testifying to it. He testified that none of the comps used in any of the appraisals were on the lake. He then pointed out that certainly that none of the comps that were in the appraisals were near properties that were affected by the ash spill. He didn't trust the appraiser because the appraiser was selected by the lender who was selected by his realtor, and he didn't trust her either. He didn't trust anybody. That was his testimony, and that was the appellant's argument in their brief. And again, they never suggested that the fair market value at the hearing or at the trial was the value on the date of the breach. The trial court took all of that into consideration, including testimony from the realtors and the plaintiffs, and he didn't indicate that the value of the property was $1 million. He said it cost $1 million to build, and he said he should have known that the appellees should have known that they would never get that back out of that property because the properties in Roane County at that time had not yet recovered from the 2009 downturn. Properties in other areas such as Knox County and Loudoun County had seen a recovery like that, and that was the testimony before the court. But Roane County had not seen that recovery, so they could have never hoped to have gotten that for it. The court testified that or found that the better measure of the fair market value on the date of the breach, consistent with the defendant's testimony, was found from the subsequent sale and not the appraisals. The trial court went to extremes to say that the marketing was the same, that the contracts were virtually identical, that it took 1 year to sell the property the first time with a single offer, which was $712,000. It took almost that amount of time, 10 months, to get the second offer, which was $550,000, for which the property ultimately sold. The court also noted that no time after the breach was there ever an offer made that was equal to the lowest appraised value even, which was $640,000. This is exactly what the trial court is supposed to do, is weigh all of the evidence and all of the testimony and determine their credibility and make findings of fact. As to the damages calculation, again, reviewed with a presumption of correctness, the appellant cites 3 cases, Bancorp v. Hatchell, Tinkham v. Beasley, and Corbett v. Amos, all of which are appeals court cases, and all of which are factually distinct. They are cases that turn on the facts that were presented before the trial court, and to the degree in those courts that they were not, the subsequent sale was not used, was because they were forced sales in the subsequent sales, or the marketing method was different. The Hatchell case does support, though, that when the correct legal standard is applied, and that has not been appealed in this case, that the burden is on the appellant to demonstrate that the evidence at the trial court actually preponderated against his findings. The Hatchell case also gives us when a subsequent sale is the better measure of fair market value on the date of the breach, and that's when the property sells on equally favorable terms, that it's for the highest and best price obtainable, and it's an arm's length transaction. And those were the exact findings of the trial court in this case. And it's important to note that the testimony offered by the plaintiff, Richard Hartigan, who is a 30-year real estate developer, He gave his valuation at $550,000, which was the subsequent sales price. But he also did independent research of properties that he could find comparably situated in other areas comparable to Roane County, since there were no properties in Roane County comparable to this one. The realtor testified that the marketing method was exactly the same and that the contracts were exactly the same. And none of that testimony was controverted at trial. It was not even challenged. The trial court in the lower court found that or held inconsistent with Simpson v. Golden Service Realty and Auction, which is a 1996 appeals court case. And when it looked to the time the property was on the market for the subsequent sale, was there any compulsion to sell, and the method of marketing being the same and the contracts being the same, and ultimately found that the subsequent sales price was the sales price or was the value on the date of the breach, and that should not be overturned. And we are asking the court to affirm that holding. To the degree the appellant raised in its brief repairs that were made subsequent to the defendant's breach, those were repairs, and the court found that those repairs necessary to preserve the value of the property. And we would suggest that in accordance with Memphis Light, Gas, and Water v. Starkey, a 2007 appeals court case, that the appellee had the obligation to mitigate that loss and to preserve the value of the property while it continued to be on the market. As it pertains to pre-judgment interest and post-judgment interest, this court looks at the award of pre-judgment interest with the standard that the trial court has to show that there was manifest and palpable abuse of discretion. The appellants argue that pre-judgment interest should not have been awarded because the value of the property on the date of breach should have been $712, the difference being zero, so no pre-judgment interest. But to the degree if there are damages, they make the argument that $550,000, when the property was ultimately sold for that price, that the plaintiff got the benefit of that money and that interest should not have accrued on that money. Pre-judgment interest was never calculated on the $550,000 because the formula was the contract price less the subsequent sales price. The interest would have only accrued on the difference. They then argue that pre-judgment interest should not have accrued on the total of the difference between the contract price and the subsequent sales price because there would have been closing costs that would have occurred had this deal closed. The court addressed that and said, well, there was no testimony offered as to what those closing costs might have been, and certainly we can't speculate to what they might have been. So even to the degree if that were accurate, that we're supposed to take that into consideration, there was no testimony offered on that subject at the trial court. Interest was computed on the $165,000 plus the special damages that were awarded for the repairs and expenses incurred after the judgment was in or after the breach. Mint v. Allstate Insurance Company, a 1998 Supreme Court case, is the case that sets out that the appeals court would not disturb an appellate court's decision. The appeals court would not disturb a trial court's decision to award prejudgment interest unless there's the finding of manifest and palpable abuse of discretion. And we would suggest that's not true in this case. As to the case of International Flight Center v. City of Murfreesboro, that case says that prejudgment interest is generally appropriate when the amount of damages to which the plaintiff is entitled is certain being determined when there's some type of standard or formula by which we can calculate the damages. And in this case, we have that very thing. We have a formula, and that's the formula that the trial court used. Again, in the Mint case, the court said that the standard of review clearly vests with the trial court as to prejudgment interest, and the appeals court should give that considerable deference. As to the award of post-judgment interest, I think the appellant's argument fails to note TCA 47-14-122, which mandates post-judgment interest on judgments that are entered in any court in the state of Tennessee. For these reasons, Your Honors, the appellees ask that the lower court's order be affirmed and not disturbed. Thank you, Your Honors.
Thank you very much. You prepared for your rebuttal?
My rebuttal will be very short. I think that we responded very amply to all the arguments that Ms. Clark raised in our brief. We're not going to recite them again. Sufficient to say that at the rehearing, We did offer a findings of fact, conclusions of law, which His Honor Chancellor Williams took as an exhibit to the case, but did not review them at the time that he rendered his decision. So all these issues that are involving the record were presented for the court's consideration, and the court did not review them at the time that the hearing was held. Other than that, everything that Ms. Clark has said, I think, is responded to in our brief, and we rely upon that, ask the court to modify the trial court's decision based upon the arguments we presented. Thank you.
Thanks to both counsel for your presentation. Your case is now being presented to the panel. You may be excused.
Thank you so much.
Ms. Clerk, will you join clerk to the next, join court to the next set court hour, please?
This honorable court is now in recess until 1:30 p.m.
Thank you.